Yes, good evening to the participants of the JCJ 2022 main examination. Karibu sana in Kiswahili. Welcome in to my class in English. Yes, the participants, please read what I posted on the screen. Anyone can unmute and read. Are you hearing me? At least say yes. I think there would be a certain problem at you. Okay, doesn't matter. I will read it. Welcome to the aspirants of the JCJ 2022 main examination, 13th October 2022, attachment of the property. So I already posted in the WhatsApp group main what I am going to teach today. When you say the attachment of the property, the introduction is a civil suit is instituted against an individual who causes some kind of harm or the wrongful act to the plaintiff. Usually, in a civil suit, compensation is awarded to the complainant. The person who suffered harm because of the action of the defendant means defendant is the wrongdoer here and who committed a certain breach or certain injury to the plaintiff. So the plaintiff he himself go to the court, tap the door of the court, and he is called the plaintiff. So a civil lawsuit can be brought over a contract dispute, a residential eviction, after a broken lease. Of course, expiry of the lease. What is the broken lease? It's better to say expiry of the lease. Injuries sustained in a car accident. Yes, we can file a suit under the Motor Vehicle Act, or countless other harms or disputes. In these, we have to file a civil dispute for the compensation. And the main objective of the instituting a civil suit is to compensate for the harm caused to the aggrieved, unlike the criminal suit, which emphasizes punishment for the wrongdoer. We don't say the wrongdoer, better we say the criminal perpetrator. So that is the particular word we have to use. Of course, it is hosted by the Professor Dr. Mohammed Saheb, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. So now let us go to our point of study without wasting the time. Participants, are you hearing me? Please say yes, no. What is the wrong today? Nobody is giving the answer or responding. So attachment of the property, so interesting facts, one must have to know it. Then we will make it out. Sir, I am in the online class, sir. I will speak you later, sir. Yes. So introduction is concerned, of course, courtesy from the Shruti Singh, Hidayatullah National Law University, from there that I have taken these experts. Introduction is concerned, a civil suit is instituted against an individual who causes some kind of harm or wrongful act to the plaintiff. So, it is a civil suit, just before that we read, instituted against an individual and who causes some kind of harm or wrongful act to the plaintiff. Who causes the harm? Anyone? Unmute and give me the. Who causes the harm? It is here is the defendant, and the harm is caused to the plaintiff, and he is an aggrieved, and he was injured, or he became financially injured at the time that plaintiff goes to the court and file a suit. Hence, a civil lawsuit can be brought over a residential eviction, just before we read it, after a broken lease, after the expiry of the lease, better word is a contract dispute, yes, injuries caused due to the car accident, or a countless other harms or disputes, what I posted on the beginning. The main objective of instituting a civil suit, is to compensate for the harm caused to the aggrieved. And who is the aggrieved here? Participant, can you tell me who is the aggrieved here? Here, aggrieved is the person who is the plaintiff. Unlike the criminal suit, which emphasizes, here we are using the British spelling, hence we should remove the Z and keep the S. Yes. Emphasize, of course, it says the red line, but we can say that ignore all. Yes, this is the emphasize the punishment. It is emphasize the punishment for the wrongdoer, perpetrator, in the criminal cases are concerned. So now let us see what will be the dismiss, I will say. There are three stages of every civil suit. What are they? It starts with the institution of a suit. Number two, first we have to institute a suit in a competent court. That's the first stage. The second stage is adjudication of a suit, means the trial proceeding or it should be continued. So, and fine, here adjudication of the suit in nothing but the judgment of the suit, either the decree or order or the judgment. And finally, the implementation of the suit. See, implementation in this, whatever the orders should be given over there, and that should be implemented. That is, in other way, we can say the execution of the order. If I may be wrong, please correct me. Yeah, that is the institution of the suit, adjudication of the suit, and finally the implementation of the suit. So, the implementation of the suit is a step in which the results of the adjudication are put into action. Just made it clear. Either it is a decree, or it is the order, or it is a judgment that will be executed over there. Once the decree or order or judgment is passed, that is called the adjudication of the suit. Hence, this stage is known as an execution. Just before I told you, execution. In this process, the order of the judgment passed by the court is enforced or given effect. Whatever the adjudication of a suit will be given in the civil court, either it is the order or the decree or the judgment, that will be implemented in the last stage. It is the enforcement of the decree and gives the benefit to the decree holder in whose favor the decree has been passed. And here the decree is passed in favor of whom? Anyone? Participants? The decree will be favored in favor of the person who goes to the court. That means plaintiff. Is it clear? Say yes at least. Participants, say yes. Okay, some problem would be there in your internet, it seems. So, it is the decree holder in whose favor the decree has been passed. Section 38 of the CPC. What is CPC? Civil Procedure Code. CPC is a acronym or initialism or shortening or contraction. Anyone? Unmute and give me the answer. Participants, it is the initialism because we are using the each letter individually, spelling CPC. So it is an initialism, it is not an acronym. So section 38 of the CPC states who can execute the decree. So section very clearly says, section 38 of the CPC states who can execute the decree, and a decree may be executed either by the court which passed it, the same court, or by the court to which it is sent for the execution. Of course, the different court where it is sent for the execution also it can be passed the executed such a decree. Section 37 gives the further explanation of certain expression. See the cursor, where I am reading. Is it clear? Either in the same court which passed the decree you can make it out, or in the another court which want to be executed such a decree. That is the same thing which is made. Section 37 gives the further explanation of certain expression. What expression it is? In a proceedings for the arrest of the judgment debtor. Of course, if he could not implement it, arrest is a must. A judgment debtor. If the decree holder satisfies the court that the judgment debtor has sufficient means to satisfy the decree, he is having the bank balance, he is having the estate, he is having the movable and immovable property. At the time, yes, the satisfies the decree, yes, he can be capable of making the payment. The court cannot refuse to order the arrest. At the time, the court will not refuse. The court cannot refuse the order to arrest. In case he becomes a default, at the time, definitely the court will arrest the person. That is the reason they say the court cannot refuse to order the arrest. Means the court will order for the arrest when he will be a default. Is it clear? The judgment debtor, when he could not execute the decree or the order or the judgment, whatever it may be there, at the time, definitely the civil court will send the arrest order to the defendant who is the defaulter. Is it clear? Participants, is it clear? So on the ground that there is an alternative remedy of attachment available to the decree holder for the realization of the decretal amount. So there may be alternative method also would be there, but Suppose if he doesn't have any money, at that time, can the court will give the order to him to sell your kidney, one kidney, because with one kidney, one man can survive. Selling the organs of the body. No, it cannot be. Whatever the property would be there, it is the duty of the plaintiff to show that he is having the bank balance, or he is having a job, or he is having the mobile and immobile property on his own name, or he is having the land, agriculture land on his own name. At the time, they have to show to the court. Then the court will attach the property in case he was the defaulter. Is it clear? Yes, participants. The Code of Civil Procedure 1908 provides various modes of execution of a decree subject to some conditions and limitations. Of course, there are certain conditions are there, limitations are there for the execution of a decree. Section 51 of the CPC provides the following modes of execution of a decree, subject to such conditions and limitations as may be prescribed under which section? Participants, is it all? It is there on the screen. We can just see and give me the answer. What is the section? Say loudly. Sonorous voice. SONOROUS. Section 15(1) of the CPC provides. A. By delivery of any property specifically decreed. Suppose a specific property is decreed over there. Yes. You have to deliver such a property, which is a mobile property, physically. It is an immobile property. Suppose the house is there, then the house of the key should be deposited. Is it clear? B. By attachment and sale or by the sale without attachment of any property. Either we can attachment and sale property, whatever the amount realized, whatever the amount will be deducted, yes, we can deduct it with the interest. Then the rest of the amount should be given back to the defendant, who is the owner of the property. Is it clear? So the same thing by attachment and sale, or by the sale without attachment of any property. Even without attachment also they can sell the property. So these are the two modes are given over there. To realize the amount and give the aggrieved party, who is the plaintiff, the decretal amount. What amount? Decretal amount. Is it clear? Say yes. Okay. Right. So now the C provision is by arrest and detention in a prison for such a period not exceeding the period. Of course, he has given the some time limit is there. So by arrest and detention a person for such a period not exceeding the period, of course they have given the specific period, but generally it will not be done so. Because they do definitely give it when the plaintiff show the amount and which property should be attached, and they will sell the property and realize the amount and give to the plaintiff with the interest till the payment of the full due. And if any leftover amount would be there, then it will be deposited in the bank of the defendant whose property was attached. The D, in such other manner as the nature of the relief granted by may require. If any other alternative remedy would be there to fulfill the condition of a plaintiff, to restore back its original position, at the time they can be follow any other relief also. Is it clear? So how many are there? A, B, C, D. These are the modes where the property is executed, the decree under section 51. These are the terms and conditions. In the case of the default, of course, imprisonment is there. Of course, limited period, not exceeding some amount. Sir, if the limited period is over, then he is need not to pay the amount. Yes, that is a point. Because if he did not, because of the default, he undergone the imprisonment and he stayed over there in the prison for some certain period, then what is going to get to the plaintiff here? Answer is, he will not get anything unless until he is having certain property to pay it. If once the period is over, I doubt, again, it cannot be done. Suppose if the both is there, yes, he is supposed to pay it. In case of the default again, okay, it may be extended. Means the incarceration may be extended, subject to the correction. If anyone can heard my lecture and if I am at the wrong, please correct me. I will be very much obliged. So now let us see the nature, scope, and objective. Attachment of the property. Attachment of the property is one of the modes of the execution of a decree in a civil suit. Yeah. If they could not listen it, then execution petition would be made. In a decree, the court may require a person, means defendant, to pay an amount to the decree holder. And who is the decree holder here? Participant, anyone can unmute and give me the answer. The decree holder is the plaintiff. Am I right? Okay. In a cases where the defendant fails to pay, means in the case of the default of a defendant, the required sum, the decretal amount, which is passed by the competent court, the court can, in the execution of its decree, attach the movable or immovable property of the defendant and recover the amount which is due by the disposal of these assets. Means they will make the sale either before the attachment or after the attachment. They can sell the property. Sell the property, and whatever the amount realized, it would be there. First and foremost, it will be clear to the decree holder of the decreal amount, and the rest of the amount again they will deposit in the bank of the defendant. Because the bank transaction is a proof. Am I right? Always do the bank transaction. Don't do hard cash transaction because there is no proof. Bank transaction means it will be deposited in the particular person's name. Then tomorrow he cannot say that I did not receive it. We can take this bank passbook or the statement which is issued by the bank with the competent authority signature. Yes, that will be a relevant evidence to produce in the bank. So, however, there are some assets which cannot be attached to recover the due amount. Certain attachment would be there. Could you attach a wife? Wife is not a, what I say, wife is a, of course, a wife is an animated thing, is a mobile property, no doubt, but one cannot. But in mythology, they say the pawn or the mortgage is the wife. Of course, that is a different issue. So now let us see what are the properties which cannot be attached. So some assets which cannot be attached to recover the due amount. To my knowledge, because once I read it, the artisans, the plow, and the bulls which they are using for the plowing, and such thing could not be attached. Suppose if such a thing will be attached over there, how could the farmer will plow it? When he doesn't have the money to hire the tractor, or he is having a tractor, but he could not know how to drive it, how to use it. But those things which are very much essential for his livelihood, and I am sure that such things could not be attached. For instance, if a mechanic is there, what is the instrument that a mechanic uses it? What is his tools? Like a plier is there, wrench is there, and many other which can open the bolt or fix the bolt, or screwdriver is there, cutting plier is there. And these are the things which are very much useful to them, including the oil. Either it is a kerosene or it is a diesel, whatever it may be. If it is rusted, then you use the kerosene to put it over there, so the rust will be washed away. So now let us see the article goes through the various modes adapted by the courts in executing a decree in a suit with a special emphasis on attachment of the property. It also examines the various provisions relating to the attachment in the court. So now let us see the property which can be attached. They say property, yes, read. Participants read, which I highlighted here. Yes, say loudly. Here they said, property which can be attached. That I highlighted. Now let us see that which property can be attached. Attachment is a legal term Okay. That refers to the action of seizing property. So the first action of seizing comes, then the attachment follows later. So action for the seizing the property in anticipation, what? Of a favorable ruling for a plaintiff whose claims to be owned money by the defendant. There is clearly a decree holder is there and judgment debtor is there, and the decree is given in favor of the plaintiff to realize the amount from the property. First seize the property, then you attach the property, then you can sell the property, then the amount will be realized. Either before the attachment or after the attachment. Both the ways a court can having a authority to attach the property, because when he is a defaulter. Who is the defaulter here? Participants. Defaulter is here is defendant. The decree holder is plaintiff. The decree holder is dominus list, means person whom the suit belongs. Decree holder means the person who instituted the suit or the suit belongs to him. That's why you can say dominus list, person to whom the suit belongs, and he has the right, not here. Yes, I removed what I removed just now? Sir, full stop. What is another name for the full stop? Synonym. Sir, we could not know it. How? Sir, what we ate in the morning, we could not remember that. How could you remember? How could we keep in our memory that thing which you told very long back? It is a period. Period. The same thing. And you know better. Okay, the same spelling and same meaning, but here the meaning is period means dot or full stop. Is it clear? Okay, shall I proceed? Participants? Okay. Now, neither the court nor the judgment debtor can force or persuade him to choose a particular mode of execution. This can be referred to from the case of V. Dharmavenamma versus C. Subramanyam Mandadi. In this case law, it is say what would be the mode of execution. So how it can be made? Whether the court would make it very much clear or not. Of course, when the attachment would be there, the court will definitely give the direction. And in the case of the default of the executive decree, at the time they will be incarcerated. He will put be another prison, and it is very much clearly mentioned over there. Of course, depending upon the offense, depending upon the amount, which is decretal amount. On that basis, it can be incarceration, that is the putting behind the bar will be counted. So, in V. Dharmavenamma versus C. Subramanyam Mandadi, in the process of attachment, the court, the request for the decree holder designates a specific property owned by the debtor to the transfer to the creditor or sold for the benefit of the creditor, and section 60 to section 64 and rules 41 to 57 of the Order 21 of the CPC 1908 deals with the matter of the attachment of the property. So both the sections will make it very much clear. Here is one is the CPC rule will be applied over there. Then orders also be passed in what way that it could be undertaken. Order 21 of the CPC and the rule 41 to 57. It gives the clear idea about it. So now let us see the section 60 CPC. Okay. Section 60 CPC 1908 describes the property which can and cannot be attached. Can attach or cannot be attached while execution. When it cannot be attached, naturally the court will not execute such a decree. As far as my narrative goes. Because if a decree would be in favor of the plaintiff, if it is not a fruitful one, then it is a futile efforts of the court to give such a decree. And several types of property are liable for the attachment and the sale in execution of a decree, like lands can be attached, houses can be attached, or other buildings can be attached, goods can be attached, money, banknotes, checks, bills of exchange, hundis, government securities can be attached, bonds can be attached, and other securities can be attached, etc. And things on which he has a disposing power. One can dispose it, such a. So those things can be attached. Is it clear? So there is express mention of particulars that shall not be liable for the attachment or sale. There are specifically, they listed out what are the things which cannot be attached. So the decree as mentioned in this section is only a money decree and does not include a mortgage decree. Please note the point. Here what we discuss is the money decree and where the various types of the attachment could be done onto the property. But where the mortgage is there, of course, there is a security would be there. And if in case of the default, at the time the mortgage property will be sold and the loan amount could be realized with the interest and the rest of the amount will be deposited in the defendant name. Is it clear? So therefore, it is important that the property not only belong to the judgment debtor, and also he has a disposing power on it. Even though it is certain properties, the judgment debtor doesn't have the power, but the court does have the power to attach it and sell it, provided those attachment properties enumerated just above, but is not the agriculture tools or the tools of a skilled man. For instance, you take a painter. Can you attach his painting tool? Answer is no. Because with that only that he is having his livelihood. Suppose if you attach those things where you could not work, then you are not going to get anything. In case of the starvation of the death, you will be responsible. Of course, court will not first give the such an attachment of the decree. Is it clear? Participants? Okay. Say loudly, clear. So in M. Balarajan versus M. Narsang, that is the case law, it was held that the said house of a judgment debtor was liable to be sold for execution of a decree as his contention of agricultural produce was declined. So as far the house is concerned, yes, it can be done. Whatever the agriculture contention of the agricultural produce was declined, and when a sufficient money would be there to clear it, at that instance one could not go for the agriculture produce, means crops. Because there is a mobile property, and the bank balance and all these things are there. When you will be happy or when you are injured amount or declared, that is a, what I say, decreedent amount is realized over there, then one should not go for the agriculture produce, which was declined. It is not given over there for the attachment. Because if you sell it, then only you will get the money, and with the money that he can clear your debts. So section 61 grants partial exemption to agricultural produce. So there is a certain exemption would be there, but generally the agricultural tools cannot be attached. Order the produce is concerned, there are certain exceptions. The state government may, by general or a special order published in the official gazette, declare any piece of agricultural land for the purpose of until next harvest season for the due cultivation of land and support of the judgment debtor and his family, exempt that property from being attached or sold in execution of the decree. It is clearly mentioned would be there such property where they are mentioned in the official gazette, either general or the special gazette, and the piece of agricultural land for the purpose. Why the piece of agricultural land? What is the purpose of it? Until next harvest season for the due cultivation of land. Okay, now continue it. For the due cultivation of land and support of the judgment debtor and his family, exempt the property from being attached or sold in execution of a decree. Suppose if you sell the crops or products of the agriculture, or you will be attached, then naturally, how could he clear the have his livelihood. Okay, it may be paid to you either in installments, easy installment with the interest. Because for livelihood, this agricultural produce will be must, for instance, if it is rising or not harvesting the paddy. At that instance, and the staple food of the South Indian is a, what is the staple food of the South Indian? Sir, wheat. Answer wrong. It is a rice. Am I right? If you go to the north, you will enjoy only the chapati and very less rice. If rice also given, it is given like a paramannam. Paramannam, a little amount, where you get a purohit or the priest will give to you in the form of, what I say, like alms. Sometimes they will. Of course, langar is different. In langar, the six langar is there. Six will make it out, irrespective of the caste and creed. You can have as much as you can, either the rice or the dal or the chapati with the sabzi or any other material would be there, which will be allowed to cook for in the langar of the six gurudwar. Yeah. So here exemption is agricultural produce will not be attached even though there is a execution of a decree. Section 62 talks about the seizure of the property. So seizure of the property first comes, then the is the procedure, then the attachment will be made. So 62 talks about the seizure of the property in the case of the dwelling house. Where case of the dwelling house, residential house would be there at the time, first and foremost, you have to seize that property. Means lock it and don't allow anybody to pass on. And keep the seal of your court. At the time, people will behave. People will definitely fear it and they don't go beyond the power of the court. So no person executing under the code will enter the premises of a dwelling house. So other than those who are authorized to go, they will be also allowed on the premises of the dwelling house. And sunset and sun, number one is after sunset and before sunrise. So at that instance, no person will be allowed. That means in the night. Am I right? Dwelling house after sunset means say about the 6 p.m. or 6:30, depending upon the place and altitude. And before the sunrise, yes, before the sunrise, one could not do. That means whatever you want to make it out, you make it in the daytime. From 6 a.m. to, yes, 6 a.m. to, of course, in the night comes by the 6:30 or 7, depending upon that, we can fix it. If it is 6 to 6 or 6 to 6:30 or 6 to 7, but not more than that. So, where a woman resides in such a house and it is not allowed to appear in a public. So, if a woman is residing over the house, if the seizure would be there or search should be there, a woman constable should be accompanied. When there is a woman, the person, and moreover, the woman cannot be arrested in the night. The person executing has to give her the notice to at liberty to withdraw and also reasonable time to do the same. A notice will be served to the person on whose house they are going to be attached or seizure. At the time, a notice is a must on the so and so thing, and you did not, you became a defaulter, and hence this execution decree against you, and it will be the first property will be seized, then it will be attached later. Once she withdraws, he has the power to enter the premises. Of course, the discretion is given over there. Suppose the woman has given the power or permission to enter into the premises at the time, she cannot again challenge it in the court of law because she voluntarily gave the entrance to them to search it or seize it or follow the decree or order or the arrest of the competent court which is issued against the wrongdoer, and that is called judgment debtor. So now, no, it's not a judgment debtor. Yeah, it is whom, against whom, when he did not pay it, and he will become on default. On the default is the wrongdoer. Yes, The person executing has to give her the notice. Yes, at the liberty to withdraw and reasonable notice will be given served over there. And once so she withdraws, but once you withdraw it, again you cannot claim it. He has the power to enter the premises. So such power you've drawn it means you have given the consent. When you have given the consent, then person could enter the premises, and that to be those premises where the court has given the permission. So that is also another point. Section 63 says that where the property attached in the execution of a decree is going on in several courts with the final decision of the court of higher grade prevails, and where the court at the same grades when the court where the case of the attachment came first will hold a higher value. See, when you go for the appeal, whatever the decision would be given over there, that holds good. Again, it will refer to the local court where he could not get it, or the court which has first issued such an order. Because generally the execution will be done through the local courts, even though the judgment will be given by the High Court. Am I right? Subject to the correction. If I may be wrong, I am not also a angel or a god or goddesses or lord. I am also a human being. And a human being is errare est humanum. To err is human being. Do you agree with it? Sir, we don't say either yes, we don't say either no also. And still 5 minutes are there. And if you want to ask anything, you can ask me. Up to the 5 minutes, I can continue it. Automatically, it will be stopped. So, again, I'm traveling. Perhaps I could not take it because I may be trained for the international conference where I have to supposed to speak on particular topic. Of course, in the brochure they have given a different topic, but I want to speak on the topic which I want to make it very much clear to you. And the topic is recent emerging trends in legal tech, then colon a new era for advocate in India. Sir, why don't you show your topic in on the screen? Okay, let me check it whether it is there. Yeah, it is there. Now the research, register research paper. Yeah, here it is there. You can see it. Yes, anyone can unmute and read what the research topic of mine is there, which I am going to speak on 20th October at Sunrise University, Alwar, Rajasthan. It is emerging trends in legal tech, means a technology in the legal field, a new era for advocates in India. So that is my topic. And a Professor Dr. Mohammed Saheb Hussain, and as you know that where I am working, Sir, already you posted it, no, sir. Then why do you want to say again? Okay, this is the topic which I am going to speak on that particular day. But those people who have sent me a different topic, so I said, please change the topic. Here you could see the. Is it visible to you? See name of this speaker and topic, keynote address, Professor Yashpal Singh, National Award Year 2004, and the third is main Professor Dr. Mohammed Saheb Hussain. Of course, they have given the conflict of sovereignty and Sujainty, the process of the impact assessment. On that, they have made me. But I already prepared this topic, which is emerging trends in legal tech, a new year for the advocates India. So this way I prepared the first introduction and the next etymology of the legal tech. Then the third point is technology in the legal sector and the legal development. Of course, these are the things which I want to make it out. Why I am showing this thing is you should also develop the habit of writing the articles, research articles. So it is a motivation to you. That's why that I would like to make it out. And any
जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मागे। गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
We live in a world full